May pardon to mention. One criminal appeal 281 of
Please
2009.
mention on Monday. Yes.
It is the hearing matter, Miller.
Whatever it may be, mention on Monday. Yes.
Supplementary list item number 1.
Service of notice to the informant.
I beg your pardon, my lord. I am appearing through virtual mode, your lordship. Yeah. In this case, your lordship has directed yesterday to me, find out whether the petitioner, anything seized from the petitioner, my lord. Yes. Yes, my lord. Anything seized from the present petitioner, your lordship. In this case, what has happened, my lord? 3 persons were traveling in that vehicle. 2 of them arrested on the spot, and the 3rd person absconded from the, fled away from that spot, my lord. After preliminary charge sheet was filed, and subsequently after preliminary charge sheet, the other person, the Trinath Rana, he been arrested. And on his confessional statement, this present petition is arraigned as an accused in this case, your lordship. And nothing has been seized from this man. And what about the criminal antecedent? He has a one criminal antecedent, my lord. He has, I have given it yesterday, your lordship. Con ଦେଇଥିଲେ କି ଗତକାଲି ଦେଖିଲେ? Principal affidavit ର. Okay, okay, got it. 4. That is after probation. 3 cases not against him. We have checked that comprehensive. That is not against him. No, what is pending against him there? Pending against him this case and another case is, my lord, PS case 94, your lords. Of similar offences. My lord, similar offences. And another case is also there. It's case number 44. 44, 394 so on so. My lord. So, including this case, there are other 2 cases. My lord, my lord. So, what is the status of those 2 cases? He had given it.
91 Haprak 94 of 23.
Yes.
He has been granted bail by this honorable
Just a minute.
in BLAPL number.
And this Lathur.
Lord, another Turekala 44 of 19 mandate.
No, there is no. That is not Turekola. They stated that it is Lathur PS case number 44 of 2019 under section 394 120B.
Lathur case is not mentioned in the list.
And you are in custody since when?
Custody since
21/11/2023, your lordship.
Charge sheet submitted under what offenses?
My lord, charge sheet submitted under section 274, 275,
277, then?
no, my lord, 274,
Yes,
275,
yes,
120B,
yes.
and 34 of IPC, your lordship.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/11/2023, and he has been charge sheeted under section 274, 275, 120B, 34 of the Indian Penal Code. He further submitted that co-accused persons Naresh Kumar Ahir and Gururaj N.B. while carrying S-cup cough syrup bottles Clonafit tablets and one plastic water jar containing some orange color liquid substances in a vehicle were detained by the Turkela police station officials. And they disclosed the name of one Trinath Rana, who stated to have been present in the vehicle but fled away on seeing the police party. Subsequently, during course of investigation, on the basis of the statement of co-accused Trinath Rana, the petitioner has been implicated in the case. The learned counsel further submits that who are the co-accused persons who have been granted bail?
co-accused person Vishnu Hathi alias Kata, Naresh Kumar Naik.
Submitted that the जो दी जन spot रे धरा हितले bail हेले.
Jone ହେଇଛି.
Acha, submitted that the co-accused Naresh Kumar Ahir has been granted bail.
Yes, my lord.
Has been granted bail in BLAPL number
7850 of 22.
7850 of 2022 as per by this court.
Yes, my lord.
By this court as per order dated
30/9/2022.
39/2022. Have you filed the copy of the bail order?
Yes, my lord. I filed this.
ଆଗରୁ ଫାଇଲ କରିଥିଲି ଯଦି ଫାଇଲ ଥିବ ତାହେଲେ ଦରକାର ନାହିଁ including some of the other co-accused persons. He further submitted that nothing has been seized from the possession of the petitioner, and as such the ingredients of the offences are not attracted. And therefore the bail application may be favorably considered. Learned counsel for the state has obtained instruction, written instruction, from the officer in charge of Turekela police station, which is dated 4/4/2024, to show that apart from this case, the petitioner has got 2 other criminal antecedents. The learned counsel for the petitioner has filed comprehensive affidavit relating to the status of the case. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, since no incriminating article has been seized from the possession of the petitioner, and his implication in the case is based on confessional statement of co-accused before police, taking into account the release of co-accused persons on bail and period of detention of the petitioner in judicial custody, as well as the ratio laid down in the case of Tufan Singh. I am inclined to release the petitioner on bail. The petitioner shall not indulge in any criminal activities. He shall appear before the learned trial court on his date. Violation of any terms and condition shall entail cancellation of that. Yes.
Item number 3.
I have filed the copy of, my lord, the petitioner appellant has been dismissed from service with effect from 16/3/2024. The copy is there.
It was not there on third when my lord and friends was appearing.
Had 16/3 I was not communicated with the same. I was communicated.
What of submission to them? उसका कुछ That has also not been communicated.
Yes, my lord. My lord queried on that on the previous occasion that demand and acceptance when is not there, only recovery. Whether that can be, your lordship, I am referring to one decision. Your lordship may kindly have a glance to page 736. Similar to my case, my lord. Reported in 2017, 66 OCR, Supreme Court 732. Your Lordship may kindly have a glance to page 736.
Just
Seven 36. Your Lordship may kindly refer to paragraph 11. As per the aforesaid version of the prosecution, the appellant was caught red-handed and the following events stand established by the credible evidence. 1. Seizure of the currency notes totaling to rupees 1,000 from the appellant. These currency notes tallied with the numbers noted earlier. Both his hands and the pocket were found to contain traces of phenolphthalein that was sprayed on the currency notes. The forensic evidence confirmed uses of phenolphthalein and sodium carbonate solution. The document including note sheet, application of the complainant for getting the sanctioned plan, receipt of challan, letter of the municipal corporation regarding the subject application, and files of the municipal corporation for the subject property were all seized from the residence of the appellant at the time of arrest. 12. It has also been established that the hands of the appellant turned pink when dipped in the sodium carbonate solution. The hands of the complainant were also washed and the solution became pink. These solutions are X, D, and XE respectively. Apart from the oral evidence of PW1 to this effect, PW2 also confirmed the same. Even the pocket of the shirt of the appellant was dipped in sodium carbonate solution and the solution became pink. Significantly, para 13, my lord. Significantly, the appellant does not dispute that the complainant had come to this place. He also does not dispute that on giving signal by PW1, PW2, as well as members of the raiding party reached where the appellant and the complainant were standing. The defense put forth by the appellant, however, was that he never demanded any money from the complainant, and the reality is that the money in question was forcibly put on the person of the appellant in order to falsely implicate him. Notwithstanding the valiant attempt made by the learned counsel for the appellant to project this defense, the record demonstrates that the appellant has not succeeded in his endeavor. My lord, my case is similar to this matter, my lord. The witness PW8 was the magisterial witness. In his presence, in presence of PW5, in presence of all other witnesses, PW3, 2, all other witnesses, the petitioner was caught red-handed and the amount has been recovered from him. Both the hands have turned to pink. His shirt pockets and also when he wanted to swallow the amount, it has been tested and it turned to pink. So the money and
what is the plea of the appellant?
nothing has been taken. Your lordship may kindly have a glance, except saying micho kotha.
In the 313 statement.
313. Your lordship may kindly have a glance, except 313. So he is to report the presumption.
He has not stated that it was thrusted.
No, my lord. Your lordship may kindly have a glance to the accused statement 313. Nothing has been. Your lordship has held on the previous occasions that the accused statement is the version between the court and the appellant. Your lordship on the previous occasion. So your lordship may kindly have a glance to the accused statement. Nothing has been stated in his accused statement, or he has come forward to report these charges.
Why are you not keeping a note that is accused statement? It should be their paper book जो अनुजाई prepare होची से अनुजाई गुड़ा का हब्बा कथा accused statement पहली गुड़ा heading कहीं. Yes.
Your lordship may kindly have a glance to accused statement question 1 and question 2. He has admitted that he was DOLO.
No, that is
at the concerned time. So your lordship may kindly refer to all the questions put to him except micha kotha.
No, se jo decoy ro sakhi kete seta PW
5.
PW 4.
Okay.
Micha kotha, except micha kotha, nothing has been said. Your Lordship may kindly glance to question number 5 and 6.
Hmm.
Your Lordship got 4.
Yes, yes, ପଢୁଛି.
It trans.
No, even in the last question that is put, ଯେ କଣ କହିବାର ଅଛି ସେଠି?
ସେଠି କିଛି ନାହିଁ, ମିଛ କେସ୍ ହେଇଛି। ମୁଁ ଟଙ୍କା ମାଗି ନାହିଁ, ନେଇ ନାହିଁ, ମୋ ନାମରେ ମିଛରେ କେସ୍ କରିଛନ୍ତି।
Last question ଟା କେତେ number question ଟା last ଟା?
ଏଟା କ୍ୱେଶ୍ଚନ ନମ୍ବର ହଉଛି 137
ବାହାର କର,
137
ମୁଁ ଟଙ୍କା ମାଗି ନାହିଁ କି ନେଇ ନାହିଁ, ମୋ ନାଁରେ ମିଛ କେସ୍ କରୁଛନ୍ତି।
In question 136 he was asked whether to adduce any evidence. He has refused to adduce any evidence. Next, my lord, I have also abhorred my objection.
Just a minute. Yes, Mr. Last.
Yes, my lord. I am referring to, I have abhorred in my objection, and also simultaneously I am citing this decision. Your lordship have gone through the same, and your lordship have also referred to in the previous orders while considering a stay of conviction. Your lordship may kindly have a glance to page 98. While considering an application under section 389, their lordships have held, Honorable Supreme Court, para 39, para 33, page 98, last page, my lord. Last but 98, last page, para 33.
Page 98.
Page 98, last page, my lord.
Hmm.
Para 33, last sentence. Para 33, last sentence, the appellate court, your lordship got.
Yes.
The appellate court should not reappreciate the evidence at the stage of section 389 CRPC and try to pick up few lacunas or loopholes here and there in the case of prosecution. Such would not be correct approach. Para 34. In the case in hand, what the High Court has done is something imperceivable. High Court has gone into the issues like political liability, delay in lodging of FIR, some over-writings in the first information, etc. All these aspects will have to be looked into at the time of final hearing of the appeals filed by the convicts. Upon cursory scanning of the evidence and record, the learned senior counsel for the convicts that either there is absolutely no case against the convicts or that the evidence against them is so weak and feeble in nature that ultimately on probabilities the proceedings should terminate in their favor. For the very same reason, we are unable to accept the contentions coming from the convicts through their learned senior counsel that it would be meaningless, improper, and unjust to keep them behind the bars for a pretty long period till they are found not to be guilty of the charges. In overall view of the matter, we are convinced that the High Court committed a serious error in suspending the substantive order of sentence of the convicts and their release on bail pending the final disposal of their criminal appeals. My lord, I have
At the bail stage?
yes, 389, consideration of 389 applications.
Hmm.
My lord, in 389, there is nothing has been mentioned regarding stay of conviction. Suspension of sentence is there.
Okay.
So, stay of conviction, no word is there, my lord, 389.
Any-
And while considering suspending the sentence, my lord.
any-
My lord, your lordship was referring to Niraj Datta's case on the previous occasion, my lord.
Hmm.
In the Niraj, your lordship of justice rightly observed, my lord,
Niraj Datta ଦେଇଥିଲେ କି?
I am giving the live law
All right,
decisions.
So you concluding paragraphs?
Yes, yes, my lord. I am coming to concluding paragraph, paragraph 67, page 25.
Just
Paragraph 6, OCR.
No, no.
22
The OCR it was it.
live law.
Therefore, this cause
I have given my lord SEC citations.
Therefore, this court was এটা para देखो
88.
Your lordship may kindly refer to page 25. Paragraph 67. Your lordship have on the previous second, my learned senior advocate had referred to the same. I am again repeating the same. Therefore, this court cautioned that even if a witness is treated as a hostile and is cross-examined, his evidence cannot be written up altogether, but must be considered with due care and circumspection, and that part of the testimony which is creditworthy must be considered and acted upon. It is for the judge as a matter of prudence to consider the extent of evidence which is creditworthy for the purpose of proof of the case. In other words, the fact that a witness has been declared hostile does not result in an automatic rejection of his evidence. Even if the evidence of a hostile witness, if it finds corroboration from the facts of the case, may be taken into account while judging the guilt of the accused. Thus, there is no legal bar to raise a conviction upon the hostile witness testimony if corroborated by other reliable evidence. Next, para 68, my lord. I am referring to 68, page 26.
ABCD.
D1. If there is an offer to pay by the bribe giver without there being any demand from the public servant, without being demand, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7 of the Act. In such a case, there need not be a prior demand by the public servant. Your lordship may kindly refer to E paragraph. Your lordship got it. The presumption of fact with regard to the demand and acceptance of obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. On the basis of the material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused. Subject to rebuttal, my lord. By the accused, and in the absence of rebuttal, presumption stands, my lord. In this case, our case, nothing has been rebutted. Neither the accused came forward, nor adduced any evidence, nor taken any plea in the accused statement. So, if in the event the complainant turns hostile or has died or is unavailable to let in his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witness who can again let in evidence either orally or by documentary evidence, or the prosecution can prove this case by circumstantial evidence. The trial does not abate, nor does it result in an order of acquittal of the accused public servant. G. In so far as section 7 of the Act is concerned, on the proof of the facts in issue, section 20 mandates the court to raise a presumption that the illegal gratification was for the purpose of a motive or reward as mentioned in the said section. The said presumption has to be raised by the court as a legal presumption or a presumption in law. Of course, the said presumption is also subject to rebuttal. Section 20 does not apply to section 13(1)(d). H. We clarify that the presumption in law under section 20 of the Act is distinct from presumption of fact referred to above in point number E, as the former is a mandatory presumption of law, while the latter is discretionary in nature. Para 70, my lord. Your lordship got para 7. Accordingly, the question, report, or consideration of this constitutional basis is answered as under. In the absence of evidence of the complainant, direct, primary, oral, documentary evidence, it is permissible to draw an inferential deduction of outpability, guilt of a public servant under section 7 and 13(1)(d) read with section 13(2) of the Act, based on other evidence adduced by the prosecution.
So what are the, according to you, what are the other evidence?
Your
which
lordship
has
may
been-
kindly have other evidence available. I have cited Om Prakash Sahani, the case that if your lordship in the event any observation is made while considering an application under section 389 CRPC, it may prejudice either of the parties, my lord. My first submission is either of the parties, if any, because all those aspects will be considered at the stage of final hearing of the appeal, my lord. At the stage of final hearing of the appeal, my lord. So I have referred to the decisions and your lordship's observations in 4 other cases. I have filed those cases. Your lordship may kindly have a glance to those filed 4 matters in which
you have underlined that.
yes. Your lordship, I am only reading your lordship's observation. I am only reading the portion what your lordship have observed. गला गेट रे जो फाइल कर फास्ट रे अछि एटा फास्ट रे एटा अछि कर सेगुड़ा से गोटा खाली कर दे जो My lord, first I have cited the citations. Your lordship may kindly have a glance in the High Court of Judicature at Patna. Your lordship got it.
Citations by ki लिखिलो ना
I have marked it in green color, my lord. High Court of Patna.
next.
Your lordship got High Court of Patna.
Yes.
The decision which I referred to, Om Prakash Sahani, it has been taken note of. Only the person in a recent decision, your lordship is second para, my lord. In a recent decision referred to 2/5/2023 in criminal appeal number so and so, Om Prakash Sahani.
They have
as-
just quoted it. There is
Yes, my
nothing-
lord. I cited that decision before your lordship.
Yes, next.
So your lordship may next refer to page 24 of the past decision 797 of 2023. Page 24, my lord.
Hmm.
Paragraph 7.
Hmm.
Paragraph 24 page, my lord got it.
Hmm.
After carefully and meticulously analyzing the finding of the learned trial court, the submissions made by the learned counsel for the respective parties and the evidence on record, I am the humble view that at this stage, it cannot be said that it is a case of no evidence against the petitioner. Whether on the basis of points raised by the learned counsel for the petitioner, benefit of doubt is to be extended to the petitioner is to be adjudicated at the final stage, when the appeal would be heard on merit. Giving any finding on the merits of the case is likely to cause prejudice to either of the parties. This court will certainly have a duty to make deeper scrutiny of the evidence and decide the acceptability of the credit worthiness of the evidence of witnesses at the final stage of hearing of the appeal on merit. At this stage, reappreciation of evidence by conducting detailed analysis and trying to pick up lacunas or loopholes in the case of the prosecution is impossible to extraordinary circumstances material
Is not
is
permissible.
not
Is not permissible.
permissible. Is not permissible.
Stop.
No extraordinary circumstances material is shown to this court for granting the desired relief to the petitioner. Similarly, my lord, in the next decision, 99955 of 2022, my lord, paragraph page 33, para
No,
7,
These are all on the factual aspect of that particular case.
particular case.
The observation.
No,
of
no,
the-
no, my lord. I am submitting before your lordship to satisfy that the decisions which have been made by the Honorable Supreme Court,
Hmm.
that at the stage of consideration of 389 applications, how
Hmm.
far it is justified,
Hmm.
whether that it will prejudice either of the parties or not. So I am submitting before my lord. Fact of the cases are different,
Hmm.
but trap case is there. The first one is trap case.
Hmm.
The second one is also 477. The third one is a trap case. So trap cases were there. I am submitting before my lord that whether at this stage, while considering an application for 389, whether we will scrutinize the evidence of the witnesses on record for an order of stay
Hmm.
at this stage, my lord. I am submitting that point only.
Hmm.
I have relied on the decisions of K.C. Sarin, Balakrisna Dattatraya Kumara, etc., my lord,
That
in
is-
which it has been categorically, it has been said that the evidence should not be scrutinized at this stage, or it cannot be ground that the applicant may lose his job. I am citing the Balakrisna Dattatraya Kumara. I have relied on, my lord.
No, he has already lost his job. So
He has lost his job. No, this the observations by your lordship in these cases, out of the 4, 3 are trap cases, my lord. I am submitting that only. So in this case also, there are other evidence available against the complainant, my lord, magisterial witness, and as your lordship has gone through on the previous occasion, overhearing witness in chief he has supported. And other constables, my lord, who were present at the time of detection, my lord, they have supported and they have proved this color pink, and it was recovered from the possession of the accused. So it was the bounden duty of the petitioner accused, my lord, to rebut that this allegation was false, and in order to falsely implicate him, the amount has been thrusted on his pocket. Nothing has been recorded on his behalf, or on the accused appellant has not come forward to say anything else. So out of the 12 witnesses, my lord, TLO is PW10, TLO is PW11. He was very much present. He has recovered, and he has also sustained injury on his thumb. And PW10 and 12 are the investigating officers, my lord. PW8 is the magisterial witness, my lord. PW5 is the overhearing witness. PW4, and interestingly, the beneficiary, my lord, I want to satisfy your lordship. One of the beneficiary has stated even though the complainant who declared hostile, through him, they wanted to get the relief of death benefit, but this accused was demanding money for getting the same. Your Lordship may kindly have a glance to beneficiary number 3. I am
So,
only...
I just don't want to go to the factual aspect, because you said just now that if I enter into all those things in detail and give some observation either way, that it may
Prejudice either party.
prejudice either way in the final hearing.
Here, man.
So question is that on the face of it, that is
Yes.
most important, whether a rare exceptional case is made out to
Yes.
show that he has got every chance to succeed.
Yes.
Detailed analysis, like in the other case you pointed out, suppose at the bail stage, somebody enters into detailed analysis of evidence, statements, etc. Obviously, in the trial court would be a prejudice. So that is why it is prohibited.
No,
in
that is
sense.
after conviction, my lord.
That's correct. So no, conviction means
After conviction, when he went to bail, bail was not granted.
in this type of cases, when let us say these two witnesses are material witnesses, and if ordinarily the one of them sometimes turns hostile, that is the complainant.
He has turned hostile, my lord.
No. Just think of it that in some cases you are adopting keeping some kind of tape records, so that what conversation was going on, because if the other person would be at a distance and it would be suppose in an office, he might not hear what is he can just see what passed on between them, and accordingly he will pass the signal. So whether it was not relevant that something should be kept, like in pain or etc. Now there are so many development. We can record it. You can video record it even also. What has transpired.
That in Umesh Menon's case, it has been. Umesh Menon case जोटा मैं दिल्ली ସେଇଥିରେ ସେଇ ଜିନିଷ
even the person who was standing at a little distance, acting as overhearing witness, even he can record in his mobile phone also, without the person might not be knowing that it is being video recorded at the distance. If you suppose sometimes you keep as if you are posing to address receive a call, and in that way your camera or video is on, so that you can record the. So something has to be adopted because of this situation. Suppose somebody turns hostile, and these things can be played in the court. He can be confronted that not only this previous statement, but this is electronic evidence has come.
Yes, my lord.
So
This
here,
PW4, my lord, this PW4, even though declared hostile, when his 164 statement was recorded, he has described the details.
no, that is
Details he has described.
no. Question is, suppose 164 statement is there, and he says
Demand is there.
he gives some a kind of explanation that I was constrained to say so before the magistrate, and this police officer, perhaps he has stated like that the
Yes.
IO.
Yes.
He
My
has
lord-
given some kind of
My lord,
that
it is
I was pressurized to say so.
yes, my lord, that may be.
Ah.
What happened to him? Why did he, my first submission before your leadership is that he was the president of one Shramika Sangha.
General Vishwakarma Sangha.
My lord, my submission, I am submitting before your lord, respectfully I am submitting. He was Tikkavalli Vishwakarma Shramika Sanghar president କାମ କରୁଥିଲା. Why did he go to the vigilance department? My first submission is, why did he go to the vigilance department? If there was no work, why did he go? Why did he submit after submission of applications before the present petitioner? Why did he go to vigilance office? Vigilance office, thereafter to the DLO office, and from where the money was recovered? if he had no duty at all, he had, and these beneficiaries were not to get any death benefit scheme. In order to satisfy your lordship, I am referring to the evidence of one beneficiary, PW3. Your lordship, PW3, one of the beneficiaries. So after doing all these things, he has stated in the court that nothing was demanded. I wanted to give, etc., etc. Your lordship may kindly have a glance to PW3. Gajapati Pradhan. Lordship got it. Your lordship, see, I do not know the accused who is standing in the dock. 4 to 5 years back, I had been to Labour Office, Fulbani. My wife, Ramanti Pradhan, was a registered labour card holder who died about 6 to 7 years back. Babuji Pradhan, my lord PW4, told me that if a card holder dies, he or she will get the death benefit of rupees 1 lakh from the government. He further told me to submit the application at District Labour Office. Babuja Pradhan took my application form for submitting the same before the District Labour Office. The District Labour Officer demanded rupees 4,000 as bribe to sanction the death benefit of my late wife. I expressed my inability to pay rupees 4,000 as bribe, but agreed to pay rupees 1,500 as bribe to the District Labour Officer. I had paid rupees 1,500 to Babuji Pradhan for giving the same to the District Labour Officer. My lord, next. Babuja Pradhan neither returned my money nor my application for getting death benefit was granted. This is my application for getting the death benefit of my late wife, marked exhibit P10, and P10/1 is my signature there. My lord, this witness has signed in Odia. This is the copy of the death certificate of my wife, marked as exhibit P10/2. This is the copy of labour identity card of my wife, Ramati Pradhan, marked as exhibit P10/3. Marked with objection. I was examined by the IO and my statement was recorded by her. Cross-examination. I had gone to District Labour Office. I had never met with the District Labour Officer. I met with Babuja Pradhan at District Labour Office. Babuja Pradhan told me that the District Labour Officer was demanding bribe rupees 4,000 for processing the application. I cannot say the date when I gave my statement before the IO. It is not a fact that I have not stated before the IO that the District Labour Officer was demanding bribe of rupees 4,000 to sanction my application. I had gone to District Labour Office twice. I cannot say the date when I had been to District Labour Office before I gave rupees 15,000 to Babuja Pradhan. 1,500. 1,500 to Babuja Pradhan. I have not made any complaint against the Babuja Pradhan before any authority. I have not made any complaint regarding demand of bribe money by the District Labour Officer before any authority. I submitted my applications exhibit B10 through Babuja Pradhan. It is not a fact that no one had demanded any bribe from me to sanction my death benefit application. It is not a fact that I am deposing falsehood. So the person is a beneficiary, my lord. Another beneficiary, although
It's all right. What do you want to say when this person has stated that whatever demand that was stated to by the complainant to him? it's
through
not-
complaint.
Just listen to this. There's a very significant difference. He did not know the accused. The very first line. Accused has never personally demanded money
From this person.
right.
He has not demanded.
Right.
Your lordship,
So,
correct.
whatever has been said was through the complainant.
Yes.
Right. Complainant said that accused wants rupees so and so for doing your work. Right. Now that very complainant has been examined as a witness in this case. What he has stated. Has he stated anything that the accused asked me money to get it from these persons, and that is how I lost the.
He has stated in chief to some extent, but he has recited from his own statement.
ଏଇ ଯୋଉ ଭର୍ସନ ଟାକୁ ଆପଣ କରୋବୋରେଟ କରିବାକୁ ଚାହୁଁଛନ୍ତି କମ୍ପ୍ଲେନାଣ୍ଟ ର ଭର୍ସନ କୁ, କମ୍ପ୍ଲେନାଣ୍ଟ ଯଦି କିଛି କହିନି ଏ ବିଷୟରେ, କମ୍ପ୍ଲେନାଣ୍ଟ କହିଛି କି ଯେ ମୁଁ ଏମାନଙ୍କୁ ଆକ୍ୟୁଜ୍ଡ ମତେ ଏଇଆ କହିବାରୁ ମୁଁ ତାଙ୍କଠୁ କହିଲି ଏବଂ ତାଙ୍କଠୁ ଟଙ୍କା ଆଣିଲି application आनिले ये सब कही ची कि ये जो जहाँ ये जहाँ
Lordship, may kindly have a glance to paragraph 6 of the complainant.
paragraph 6
6.
हाँ कौन है complainant is PW 4
4.
अच्छा देख आनो देख paragraph 6 is that previous statement which you have confronted, right? And that he has again stated in the cross examination that this very one line is sufficient. I have never gone to the accused before 7/11/2009 in paragraph 11 with regard to the applications of 4 beneficiary. এই যে গোটিয়ে particular line ଆସିଲା ଆପଣଙ୍କର এইটা totally falsify କରିଦଉଛି ଯେ ସିଏ accused କୁ complainant କେବେ meet କରିଥିଲା accused ତାକୁ କହିଥିଲା ଏତିକି ଟଙ୍କା ଆଣିବା ପାଇଁ ଏବଂ ସେ accordingly ସିଏ beneficiaryଙ୍କୁ କହିଲା beneficiaryଙ୍କୁ ଟଙ୍କା ଆଣିଲା ତାଙ୍କଠୁ ଦରଖାସ୍ତ ଆଣିଲା ଆଣିକି
ଦରଖାସ୍ତ ଗୁଡାକ ସିଜ୍ ହେଇଛି
ଦରଖାସ୍ତ ସିଜ୍ ହେଇଛି that's a different matter but question is that ଆପଣ ଯଦି କହୁଛନ୍ତି ଏଠି ଆପଣ କଣ କହିଲେ ଯେ ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ କିଛି ନାହିଁ କାରଣ PW କମ୍ପ୍ଲେନାଣ୍ଟ ହୋଷ୍ଟାଇଲ ହେଇଗଲା ମାନେ ଏଇ ଯୋଉ ଡିମାଣ୍ଡ ଆଉ ଇଏର
yes my lord
ରାଇଟ୍
yes
ଆପଣ ଗୋଟେ ଲିଙ୍କ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଯେ ବେନିଫିସିଆରୀ ଗୁଡାକ ଏଇ ଜିନିଷ ଗୁଡାକ କହିଲେ
beneficiary କହିଛନ୍ତି ଏ PW4 through ରୁ
But
ସବୁ ଯାକ ହୁଏ your lordship is absolutely correct that everything is done through PW4
ରାଇଟ୍
he has resigned from his own
ହଁ।
doings
ସେଇ ଯୋଉ ବ୍ରେକ୍ ଟା ହେଇଯାଉଛି ବର୍ତ୍ତମାନ ଯୋଉ ବ୍ରେକ୍ ଟା ହେଇଯାଉଛି ବର୍ତ୍ତମାନ ବ୍ରେକ୍ ଟା ହବା ଦ୍ୱାରା legally whether other evidence would be accepted
yes
or not.
yes my lord other evidences are there as I read the decisions of Umesh Menon
No, that is there.
that is there other evidences are there other evidences who are there regarding recovery recovery of the amount from the possession of the accused
No, this please keep it in mind that that is a 2-judge bench decision.
Yeah.
And subsequently the 5-judge bench decision has come, which you just
judgment
played.
I have read
So the view taken by the what he has stated in that 2-judge bench decision that if the recovery aspect is
There.
acceptable is there and some other evidence are there like this hand wash etc that would be sufficient.
sufficient
But what is the view of the Honorable Supreme Court in that 5-judge bench?
yes
Has
that
they stated that only on the basis of recovery, if there is no other evidence, that the conviction can be sustained? They have completely said in a different way. You have just read it out. Only on basing on recovery can the conviction would be sustained.
that I read
5-judge bench. अरे आपण प्रेस करे परा मु सेया कहूची
that I read my lord
ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ସେ 2-judge bench decision ଟାକୁ ମୁଁ ରିଲାଏ କରିବି ନା 5-judge bench decision କୁ ଯୋଉଟା କି subsequent decision ମୁଁ ତାକୁ ରିଲାଏ କରିବି
ସେଇଟା ମୁଁ ପଢିଲି paragraph
ସେଇ ଆପଣ ଯୋଉଟା ପଢିଲେ ମୁଁ ସେଇ ବେସିସ ରେ କହୁଛି ସେଇ ଆପଣ ବର୍ତ୍ତମାନ
5 judges bench ର
ହଁ
again I am reading
5-judge bench ର ଆପଣ ପ୍ରଥମ ଯୋଉଟା observation କରିଛନ୍ତି 68 ର ଫାଷ୍ଟ ଜିନିଷ
68 ର D ଟାକୁ ମୁଁ ଯାଉଛି
ନାଇଁ ଯିବା ପୂର୍ବରୁ ଆଗେ ଆସନ୍ତୁ
ହଁ proof of demand and acceptance of illegal gratification by a public servant is a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servant under section 7 and 13(1)(d) 1 and 2 of the act fact in issue
Yes.
this is fact in law and fact in issue
Yes.
in order to bring up the guilt of the accused the prosecution has to first prove the demand of illegal gratification and the subsequent acceptance of the matter of fact. This fact in issue can be proved either by direct evidence, which can be in the nature of oral evidence or documentary evidence. Further, the fact in issue, namely the proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct oral or documentary evidence. In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servant, the following aspects have to be borne in mind. If there is an offer to pay by the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7 of the act. Here demand is not there. as per the version of the PW4.
ଏଇ ଯୋଉ ଜିନିଷଟା କହୁଛି, if there is an offer, the how do you establish if there is no direct evidence? How did you say it is a case of offer? Suppose X goes and say that please take this money and do this work. He offers him. That is an offer,
Yes,
right? And accused takes that money, keeps it in his pocket.
yes,
So offer and acceptance. Here there is no demand. This case I am giving illustration, there is no demand.
yes.
He voluntarily goes, offers it, and the accused accepts it.
So this is acceptance, my lord.
Right.
So how
What has been stated by PW4 in the cross-examination, whether it would come under offer or it is a case of thrusting the money. Can you say, if I go to X and say that please accept and he accepts, and if I go and forcibly thrust the money inside the pocket, whether these two are same thing?
my lord, in fact, the amount has been given to the accused, but so far the evidence are available, it is absent. My submission
So
is
you'll go by evidence.
no. The evidence is that unless and until suppose he has thrusted the money in his pocket,
Yes.
how could both the hands be turned to pink?
No.
Unless and until he has counted the same, how could both hands turn to pink?
Let us say that those things are suspicious features of this case. ହେଲା ଆପଣଙ୍କର ତାର ହାତ କେମିତି ଆସିଲା, ସେ ଯଦି ରିକଭରି କରିନି, ତାକୁ ଆପଣ ଟଙ୍କା ବାହାର କରିବାକୁ ନେଇଛନ୍ତି, କେତେବେଳେ ସେ ଟଙ୍କା ବାହାର କରିଛି, କଣ ହେଇଛି, that's a different matter.
ଟଙ୍କା ବାହାର କରିବା is a different thing. ଟଙ୍କା ଯେତେବେଳେ କ୍ୱେଶ୍ଚନ ତାକୁ କରାଗଲା, why did he swallow this?
No,
ଯଦି ସେ ଟଙ୍କା ନେଇନି, ଡିମାଣ୍ଡ କରିନି, କିଛି କରିନି, ସପୋଜ ସେ ଡିମାଣ୍ଡ କରିନି, PW4 ଜବରଦସ୍ତ ଟଙ୍କା ଦେଇଦେଇଛି,
swallow କିଏ କହୁଛି evidence?
ସମସ୍ତେ କହୁଛନ୍ତି. I am referring to the evidence of 5 witnesses who were present there. 5 witnesses. What made him to swallow?
Yeah, just no, you go one by one, right?
Right.
Start from the complainant. Agitated about swallowing.
Complainant
Just
pakku
go one by one. We'll go by one, I'm telling you. PW, the 4 is the complainant, agitated about swallowing.
I have not gone through the entire evidence.
अरे आपको कॉपी दिया हला आपन कहबे
ना कॉपी अछि मो पाखरे,
ताले
मो PW वर्तमान PW2 ठु आरंभ करियो, PW2
ना किए खाली मते मु देखिबी ताको आपन किए कहिचंदी
PW2
हां
कहिछि,
सेती खाली कहि मु वेरीफाई करबिन
PW2
हां मु लेखि नउची हां आई विल वेरीफाई PW2 देन
PW4 5
yes
PW5 overing evidence, my lord.
हला कहि जान तो अपन
PW8
Hmm.
even in the cross examination PW8
शिवरा कहिले मु वेरीफाई करबी जे
PW9
Hmm.
PW11
Hmm.
yes, that's
अच्छा this he was trying to swallow the tainted money.
ହାତ କାମୁଡି ଦେଇଛି, ତା ଖଣ୍ଡିଆ ହେଇଛି.
All right. Then that saliva was collected or what?
Saliva was collected,
Not
sent for chemical examination,
Saliva collected,
sent for examination,
sent for C and detected film
detected.
No.
Yes, I am referring to
aspect रे भूल करंतुनी आपण
Not it.
saliva collected, sent for C and phenylephthalin was found in that. is it a factually correct or incorrect statement?
Chemical examination report is there.
Chemical examination report रे कौन आछि मु collect हेछि के साली भाबली किए कहूछि आपनकर जे ट्रैप लेइंग ऑफिसर कहूथिबो ना
हाँ
TLO
हाँ हाँ
TLO is PW
PW 11
हाँ PW 11 कहूछि तार सालिवा कलेक्टेड हेछि बोली
PW 11
मैं कनेक्ट करथिले बट पठेई नांती एग्जामिनेशन पे
ओ लाइन ने अछि सालिवा कलेक्ट हेइतिला
सालिवा कलेक्शन हेतला मु काली पढुथिली PW 8 रो जे मैजिस्टेरियल विटनेस
पठेई नांती बोली कोड मिस्टर धौड़ी फाउंड Okay, come to paragraph number 8 of PW 11. 1, 2, 3, 4, 5, 6,
solution the
7,
from the mouth was collected in a cotton
8,
swab.
7, 8 lines from the top of that paragraph, paragraph number 8. On being asked, the accused where he kept the bribe money, the accused tried to put the tainted money in his mouth to swallow the same, to which I obstructed the accused, bite my left hand thumb finger. Then we recovered the tainted money from the mouth of the accused and handed over to Shrikant Mishra, magisterial witness, to count and compare with the earlier noted number. तापर से tally कला ही कला. Then
Your Lordship may kindly have a glance to the magisterial witness PW 8 in paragraph 2.
Acha, just come to the last line of that page number, paragraph number 8 of that very page number 6. The saliva from the mouth was collected in a cotton swab and dipped in the sodium carbonate solution, which also turned pink color. The said solution was collected preserved, and in a sample bottle marked as Exhibit F. The paper in which so this is Exhibit F.
Exhibit F has also been corroborated by PW 8 in paragraph 2.
No, see, बर्तमान exhibit देखियो आमे. तो जो Exhibit F रे C report के थे जी मार्क है.
Paragraph 16 LOBD. Paragraph 16.
कहाँ?
Say PW 11. Because examination. The accused was in custody till preparation of the detection report. I admit to DHS good morning for treatment of my injury before preparation of my detection report. Some of the tented currency notes were in negligible torn conditions, which were seized by me, and this fact has not been mentioned in the seizure list. I have not produced the accused before the medical officer who examined me to ascertain that the teeth of the accused caused the injury of the finger. I have collected the saliva from the mouth of the accused, but I have not sent the sample saliva along with the seized tented notes, which the accused tried to swallow to RFSL's Barabar. Do you think that will come in contact with valentine malaria will turn pink?
Your Lordship may
Whether the
kindly,
seized dented notes contain the saliva of the accused. The entire thing is like that.
Your Lordship may kindly refer to Exhibit 32. It will be there. Whether
He has not sent your witnesses.
no, if is there or not, chemical examination report is not available.
କେମିତି ପୁରା କହୁଛନ୍ତି ଆପଣ ଦେଖିଲେ ପରା ସେ ଲାଇନ ଟା ଦେଖିଲେ ନା ନାଇଁ ପାରାଗ୍ରାଫ 16 ସିଏ ଗୋଟେ ପଢିଲା ବେଳକୁ ଆପଣ ଦେଖିବେନି ଆନ୍ସର କେମିତି ଦେବେ
ହଁ ଲେଖିଛି ଦେଖିଛି
ସୋ
I have collected the saliva from the mouth of the accused. ସେଟା ମୁଁ ଦେଖିଲି ପାରାଗ୍ରାଫ 16 ସେ ରିପୋର୍ଟଟା ନାହିଁ ତ ରିପୋର୍ଟଟାରେ ଥିବ
ପଠେଇନାହାନ୍ତି report
A B C D E F
ରିପୋର୍ଟ କେମିତି ଆସିବ ପଠେଇଲେ ସିନା ରିପୋର୍ଟ ଆସିବ
ନା,
ସେଗୁରା ମନା କରୁଛନ୍ତି ଆମେ ପଠେଇନୁ ବୋଲି ସେ କହୁନି କି ଆଇଓ କହୁଛି ମୁଁ ପଠେଇନି ତାକୁ ସାଲିଭାଟା ମୁଁ ଆଇ ହାଭ ନଟ୍ ସେଣ୍ଟ ଇଟ ଆଉ ଆସିବ କୋଉଠି ରିପୋର୍ଟ
ଆଜ୍ଞା ସିଏ ପଠେଇ ନାହାନ୍ତି that is true. Your Lordship may kindly have a glance to evidence of PW 12 paragraph 5. Paragraph 5. Your Lordship is satisfied that that has been marked as Exhibit F. Your Lordship is satisfied that Exhibit F mark ହେଇଛି
କଣଟା ଏକ୍ଜିବିଟ
ଏଇ ଯୋଉ ସ୍ୱାଲଟା ଯୋଉ ବଟଲଟା ସେଟା Exhibit F ମାର୍କ ହେଇଛି ବୋଲି Your Lordship is satisfied.
ମାର୍କ ହେଇ ଆରେ
ହଁ
ମାର୍କ
ହଁ ପଠା ହେଇଛି କି ନାହିଁ ପରା
ସେଇଟା ହଁ
ହଁ Your Lordship may kindly have a glance to the evidence of paragraph 5.
सी रिपोर्ट ଟା କୋଡାଲା କେତେ ନମ୍ବର ମାର୍କ ହେଇଛି
My lord also see evidence of this witness PW 12 paragraph 11. I have not checked the saliva of the mouth of the accused and the seized tented currency to RFSL Barampur for examination and opinion whether the tented money notes contain any saliva of the accused. Evidence is read as not.
No, what about that C report ଟା କେତେ ମାର୍କ ହେଇଛି
32.
it's exhibit list our 32 how then this C report indicates that this exhibit F was also sent and it contained phenolphthalein in the C report has been marked as exhibit something. It contains 5 अच्छा forwarding report ଟା କଣ ହେଲା କାରଣ ସେ କହୁଛି ଯେ it contained 5 sealed bottles କିନ୍ତୁ ନମ୍ବର ଦେଖିଲା ବେଳକୁ 1 2 3 4 5 6 7ଟା ବୋଟଲ ହେଇଯାଉଛି देखी रेकॉर्ड टा देखी
7ଟା ହବାର କାରଣ ଅଛି। The paper in which the fourfold the amount bribe money was kept, that was marked as G.
ନା ନା ସେ କାହାକୁ ମାର୍କ ହେଇଛି ସେଇଟା ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ ଜଣା ପଡିବ।
ହଁ
ଏଇଟା
ନାଇଁ ଆଉ ଗୋଟେ ଯୋଉ ଅଧିକା ହଉଛି
ଗୋଟେ ନୁହଁ ଦିଟା ଅଧିକା ହଉଛି। ସେ ଯୋଉ ଇଏରେ ଲେଖା ହେଇଛି ଆପଣ ଦେଖନ୍ତୁ, ଇଟ୍ କଣ୍ଟେନ୍ଡ 5 sealed glass bottles. Sealed glass bottle marked as exhibit A, B, C, D, E, F. C report ଟା ଅଛି ତ ଆପଣଙ୍କ ପାଖରେ? That is exhibit 32.
ନାଇଁ exhibit କିଛି ନାହିଁ।
Exhibit 32 ର ଏଇଟା 32 ତ exhibit 32 ର ଇଏଟା ବାହାର କରିଦିଅ, ଗୋଟେ ପ୍ରିଣ୍ଟ ବାହାର କରିଦିଅ, ପ୍ରିଣ୍ଟ ବାହାର କରିଦିଅ immediate।
A B C D E F G 7ଟା ପଠା ହେଇଛି।
ଦେଖୁନାହାନ୍ତି ସେ ଦବ।
ହଁ 7ଟା ପଠା ହେଇଛି। କାହିଁକି ଆଉ ଗୋଟେଟା କଣ ସେଇଟା ମୁଁ କହୁଛି ଯେ ଯୋଉ ପେପରରେ ବ୍ରାଇବ୍ ଟଙ୍କା ରଖା ହେଇଥିଲା that also turn to pink।
ଗ୍ଲାସ ବଟଲ କଥା କହୁଛନ୍ତି ଆପଣ, ନ ଦେଖିକି କାହିଁ ଷ୍ଟାର୍ଟ କରୁଛନ୍ତି ଆର୍ଗୁମେଣ୍ଟ? ଆଗେ ଜିନିଷଟା ଦେଖନ୍ତୁ କଣ ଅଛି। ଭଲ ସେ ପଢନ୍ତୁ କଣ ଲେଖା ହେଇଛି। 5 glass bottles
Glass bottle marked as exhibit E।
5 glass bottles ବୋଲି ଲେଖା ହେଇଛି ନା ନାଇଁ? The cardboard it contained 5 sealed glass bottles marked as exhibit A, B, C,
Yes.
D, E। ପାଇଲେ ତ?
Yes।
So 5ଟା sealed glass bottle ପଠା ହେଇଥିଲା, ନମ୍ବର ହଉଛି 5 କିନ୍ତୁ ଆକୁ ଗଣିଦେଲେ ହଉଛି 7। A, B, C, D, E, F।
ଟାଇପୋଗ୍ରାଫିକାଲ ମିଷ୍ଟେକ୍।
ସେଇଗୁଡାକ ହଉଛି, ସେଇଥିପାଇଁ
ଟାଇପୋଗ୍ରାଫିକାଲ
ଡାଉଟ ହଉଛି ଯେ ସେଇ ଯୋଉ ଜିନିଷଟା ପଠା ହେଇନି ଭୁଲରେ ଏଠି ଉଲ୍ଲେଖ ହେଇଛି।
ନାଇଁ ଏ ତ କ୍ୟାଟାଗୋରିକାଲି ଲେଖିଛନ୍ତି ତାର ଏକ୍ସାମିନେସନ ରିପୋର୍ଟ ଟା ନା, ତେଣୁ 5 ସେଟା 7 ଜାଗାରେ 5 ଟାଇପୋଗ୍ରାଫିକାଲି।
Maybe ହେଇଥାଇପାରେ।
କାହିଁକି ନା କ୍ୟାଟାଗୋରିକାଲି 1 2 3 4 ୟୋର ଲର୍ଡସିପ ୱିଲ୍ ଫାଇଣ୍ଡ କୋଉଥିରେ କଣ ବାହାରିଲା, ଏଟା ରିପୋର୍ଟ ଟା ତାଙ୍କର କେମିକାଲ ଆଗ୍ରୋନୋଲଜି ରିପୋର୍ଟ ନା।
Running report ଟା ପଢ।
ସେଇଥିରେ ରେଜଲ୍ଟ ଅଫ ଦି ଏକ୍ସାମିନେସନ ରେ ଅଛି phenolphthalein was detected in the sodium carbonate solution contained in the glass bottles marked as exhibits B,
ସେଇଟା ଦେଲେ ତାଙ୍କୁ
C,
3 ଟା ଦେଇଦେଲେ।
D, E, F and G।
Just a minute, and see this forwarding report 33 ପାଇଲେ। 33 ଟା ପାଇଲେ। 33 ର ହଉଛି 3ଟା ପେଜ। You hand it over to Mr. Das, xerox କରିବି। Coupling କରିକି ଦିଅ। Mr. Das, please see this forwarding report. Forwarding report ରେ କଣ କଣ ପଠା ହେଇଥିଲା list of articles ରେ ଦେଖନ୍ତୁ। ଆପଣଙ୍କର ଆଇଟମ ନମ୍ବର ହଉଛି 6 ନମ୍ବର।
6 one sealed glass bottle containing light pink color solution, wash of the inner saliva wash, inner mouth wash of the active Ranjan Kishore Behera, district labor officer Fulbani, was taken with the help of a cotton swab and dipped in sodium carbonate solution, collected during detection on 7/11/19 marked as
So
exhibit
you
A।
are right that instead of 5 it should have been mentioned as 7. Yes, Mr. Dhar।
7 ରେ ମାଇଲର
Yes,
7 ରେ A ରେ ଆସିନି, A ରେ ପିଙ୍କ କଲର ଆସିନି, ଆଉ ସବୁଥିରେ ଆସିଛି।
Mr. Dhar, even though that 2 witnesses have stated that this particular glass bottle which was containing saliva was not sent, but the documentary evidence. Have you seen that forwarding report? ଟିକେ ଦେଖେଇଦେଲେ ତାଙ୍କୁ forwarding report ର item number 6 ଟା ଦେଖନ୍ତୁ ଯୋଉଟା list of articles.
One sealed glass bottle containing light pink color solution. Was of inner saliva was, inner mouth was of the accused Ranjan Kishore Behra, so and so, labor official Gulwani, was taken with the help of cotton swab and dipped it sodium carbonate solution. It was taken.
ଆରେ ଟିକେ ନୁ ଏଇଟା forwarding ହେଇଛି ପରା ଏଇଟା forwarding
ସେଇଟା
report
forwarding letter.
ଏଇଟା ପରା exhibit 33 ଟା is a forwarding report.
For that reason, I was drawing my alert's attention to the evidence of PW12.
ଆପଣଙ୍କର which is to be believed. It's a documentary evidence which indicates that these are the bottles which were sent, and the scientific officer, he has examined also exhibit F and noticed that in that bottle this was the thing was available.
No, well,
So
it's not there in exhibit F, but
Sorry?
they say
exhibit F रा ପଠା ହେଇଛି ଆପଣ ସେଇ ଯୋଉ ଦିଟା ସାକ୍ଷୀ ପଢିଲେ ସେମାନେ କହୁଛନ୍ତି ଆମେ ପଠେଇନୁ କିନ୍ତୁ forwarding report ଦେଖଉଛି ଯେ infact ସାଲିଭାର ଯୋଉ ୱାସ୍ ଟା ସେଇଟା ମାର୍କ ହେଇଛି exhibit F ଯୋଉଟା ବି ସେମାନେ କହୁଛନ୍ତି exhibit F ହିସାବରେ ଏବଂ ସେଇଟା ପଠା ହେଇଛି C report କୁ ତା ଉପରେ ମଧ୍ୟ ସେ scientific officer opinion ଦେଇଛନ୍ତି ଯେ it contains phenolphthalein.
no, it was there. It was there in the evidence of PW11. The moment it was seized, it was turned to pink.
No.
But with regards to whether the saliva has been sent, it's not there.
ସାଲିଭା ଯୋଉ ସେଣ୍ଟ ହେଲା oral evidence ମନା କରୁଛନ୍ତି
PW12 ପଠେଇବା ଲୋକ ପରା କରୁଛି PW12.
11-12 କିନ୍ତୁ
But-
documentary evidence ଦେଖଉଛି ଯେ ଏଇଟା ପଠା ହେଇଛି ବୋଲି।
Let me see the evidence of this witness before I comment on this. Paragraph 7.
So you see all these details I cannot
No,
analyze
my
that these
lord,
days.
for that reason, I have not, in the note which I have given, I have just commented on 4 and 5. I have not gone to this aspect. The exhibits, my lord, may see evidence of PW12, paragraph 7.
12-12.
Beforehand, my lord, we see paragraph 5 also. That is important. On 20th January 2020, I examined beneficiaries and some other witnesses and recorded their statement. On 11/2/2001, I received the chemical examination report along with sealed parcel from RFSL Barampur through SP Vigilance Barampur. I perused the same and found that phenolphthalein was detected in sodium carbonate solution contained in the glass bottles marked as Exhibit B, C, D, E, F, and G. It is further ascertained that phenolphthalein could not be detected in the sodium carbonate solution contained in the glass bottle marked as Exhibit A. It is further opined that seal of the Exhibit A to G tallied with the specimen seal impression taken on sheet of paper enclosed. I deposited the seal parcel in the Fulwani unit Malkhana on 11/2/2020. I examined some of the witnesses and recorded their statements in separate sheets. On 27/8/2020, I have been directed by the SK Vigilance Barampur to hand over the charge of investigation of this case to Srimati S.K.SAHOO, Inspector of Vigilance, Fulwani, unit on my transfer to Barampur's division office. This is the full print, not to say. Exhibit A to Z are the sealed sample bottles marked as MO12 to MO18. This is the specimen brass seal impression, paper marked as so and so. This is the chemical examination report of sample sealed bottles, Exhibit A to G, marked as P32. This is the forwarding report so and so.
Marked as exhibit P32.
That is the he says
No, this our next line to be hochi se this is the forwarding report of
Please
exhibit A to G marked as P.
of exhibits A to G to RFSL Barampur for chemical examination marked as exhibit P33 PW12.
Yes.
PW12 had said it. This is the receipt of the in the token of receiving sample bottles by RFSL Barampur marked as exhibit P34.
So in view of this chief examination
My lord.
and coupled with the documents itself,
My lord.
that is 32 and
And he
33.
himself has stated it cross.
बस ସେଇଆ କହୁଛି ଯେ ଏଗୁଡାକ ବର୍ତ୍ତମାନ ଷ୍ଟେଜ ରେ ଏଗୁଡାକ ଡିଟେଲ
No, I'm not
ପଶିବା
going to
ଉଚିତ
that also
ସେଇଥିପାଇଁ
because
he has rightly pointed out that if I enter into the detail of these things, then the learned court who will decide the appeal ultimately, finally, he is likely may not, this observation may go in his favor, in your favor,
Valid.
whatever it may be.
Valid.
So, এই সব জিনিଷ মাইন্ୟୁଟ ଜିନିଷ ଗୁଡାକ
submission before my lord
ହଁ
is, my lord, question of demand and acceptance.
that is different, but ଏଇ ଯୋଉ
what
ସାଲିଭା ଅନ୍ୟାନ୍ୟ ଜିନିଷ
I want to submit, my lord,
ହୁଁ
question of demand and acceptance is the sine qua non of the offense under section 7 of the PC Act. My lord.
ହୁଁ
Now, my lord, on the considering the evidence of PW4 and 5, my lord will reach at a conclusion, at least at present, that there was no demand and no acceptance. So now remains
the offer
the tented money which was alleged to have been given to me by PW4 or thrust upon in my pocket by PW4. My lord, I have gone through all the judgments delivered by my lord.
no ଏଇ factual aspect ରେ
I'm
ଆସନ୍ତୁ
not going to that factual aspect. This is also, my lord, factual aspect. If you will go to the evidence of PW11 and 12,
ହୁଁ
my lord, here at this juncture, my lord, I want to say, my lord, I have gone through almost all the judgments delivered by my lord till date
ହୁଁ
on the while deciding appeals under section 7 and 13 of PC Act, my lord.
ହୁଁ
My lord, before Neeraj Datta's case, my lord has also observed how to appreciate the evidence of hostile witness. What would be the appreciation if the tented money will be available, divorce from this demand and acceptance, what will be the consequence? All points have been decided by this honorable court in earlier point of time. My lord, with regards to recovery of tented money and the reaction of the accused with the money, that also my lord has held in a case relying upon 81 Supreme Court 765 Sankarlal Gayaslal Likit versus State of Maharashtra. This is the working of human mind. When you will face a situation like this, what would be his action? What he will do? That has also been dealt by my lord in one of the judgments, my lord, I have gone through. And also, my lord, cases of in the present nature, that has happened. If officer who has been chased by the vigilance officials, my lord, my learned friend has not stated so. Earlier, my lord, vigilance officials had also initiated a case against me in the year 2007 or 9. Till date, they have not in a position to submit charge sheet. They are chasing me time and again and want to put me in trouble time and again. And petitioner, who is a responsible officer, definitely, my lord, he will be disturbed. And the action, my lord, when money is paired with this solution, definitely, my lord, wherever it will be there, color will be changed, or there will be pink color. And they are saying that they have sent the saliva. And if that was the saliva has been sent, what is the report, my lord? I don't think the report says so because PW12 says MO12 only, except MO12, other MOs are empty. What is the report of the chemical examination? That is that because PW person who has sent it, or persons, two investigating officers, PLO and PW12, those who have sent it, they said we have not sent it in cross examination. And if that document is available through SP, that tells a story behind this curtailment. The way the things have been happened, the way the case has been organized, the best persons to say is the department why and how they are doing cases against whom and how. Why? Here, I have tried to explain, my lord, the judgments on the point and facts involved in the case. Only I have construed evidence of PW4 and 5 as discussed, my lord, as I had argued in the last occasion. And I have tried my best to say that, well, and if evidence of PW4
Please
and
give it
5,
closing the order for delivery of order.
Madam, I have given this note also, madam, with all citations.
This, এটা দিও। Give it. Okay. हाँ हाँ ଆଙ୍କର ଅଲଗା ରଖିବ ହଁ ହେଲା ये citation ଆଉ ଇଏଟା ରଖିବ ତାଙ୍କର ଯୋଉଟା ଦେଇଛନ୍ତି ଅଲଗା ରଖିବ ହେଲା
Page mark the citations.
ଆଉ ଏଇଟା ଷ୍ଟାପଲିଂ କର ଏଇଟା ନିଅ
Exhibit ଗୁଡାକ ନଥିଲା। I am obliged by not the two exhibits.
ନାଇଁ ନାଇଁ these are very much necessary sir
ଏଟା important document କିନ୍ତୁ
ହଁ।
ଆମର
No,
ତିଆରି ହେଲେ ଯାଇକି
sir.
ଯାହା ହବ।
no, it's all right.
Okay, ନାଇଁ।
No, why are you not asking them when
Exhibit ସେମାନେ
they are providing? Oh, nowadays you see,
ପଠେଇଦେବି।
ଆପଣଙ୍କର ଯୋଉ ସ୍କାନିଂ ଟା ହଉଛି ନା ଏ ସ୍କାନିଂ ଟା ଏଠି ହଉନି ଏ ସ୍କାନିଂ ଟା ସେଠୁ ହେଇକିନା ଆସୁଛି କାରଣ original record ଟା ଏଠିକି ଆସୁନି just think of it and accordingly instruct them ଯୋଉ trial court record ଟା original ଏଠିକି ଆସୁନାହିଁ ସ୍କାନିଂ ହେଇକିନା ଆସୁଛି ଯଦି ଆମେ ଯୋଉ କେସ୍ ରେ ଚାହିଁବୁ original LCR ଟା ସେଇଗୁଡାକ ସେମାନେ ପଠେଇବେ right clear ତ ଯଦି ସ୍କାନିଂ ହଉଛି it is available you can your with a pen drive that entire thing can be collected ଯୋଉଟା ସ୍କାନିଂ ହେଇ ଏଠି ଆମେ ଯୋଉ କହୁନୁ ଏଠି admit call for the trial court record ସେଇଟା ସେମାନେ ଏଇ ଅର୍ଡର ସେ ଜାଣିଛନ୍ତି ଅପିଲ ଏଟା କନଭିକ୍ସନ ହବ ମାନେ କନଭିକ୍ସନ ହେବ ମାନେ ସେମାନେ ଟ୍ରାଏଲ କୋର୍ଟର ସ୍କାନିଂ କରି ରଖିଦେଇଛନ୍ତି ଦି ମୋମେଣ୍ଟ ଇଟ୍ ଗୋଜ କଲ୍ ଫର ଦି ଏଲସିଆର ସେ ସ୍କାନ ଇଏଟା ପଠେଇ ଦଉଛନ୍ତି ରାଇଟ୍ ଯୋଉ ସ୍କାନ ଟା ପଠଉଛନ୍ତି so it can be collected in a pen drive and it can be given to you and in once the entire LCR will be with you you need not say the state council to the other side appellant council to provide you deposition slip this exhibit list these are the things so you just ask your that officer that yes special pp just give a pen drive and hundreds of LCR will be collected in one pen drive ଯୋଉଗୁଡାକ ଆପଣ କଲ୍ ଫର LCR ହଉଛି ନା ଖାଲି ସ୍ପେଶାଲ ପିପି କୁହନ୍ତୁ ସ୍କାନିଂ ହବ ଆପଣ ଗୋଟେ କଲେକ୍ଟ କରିକି ଦେଇ ଦିଅନ୍ତୁ କାମ ସରିଲା ଆପଣ
LCR is called for how paper book will be prepared.
no no
A scan
scan copy ରୁ paper book that legible ହବ ହଉଛି ନା paper book no 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 that is now that is the full court has passed so there is no problem in that so ଯୋଉ କେସ୍ ରେ ଆମର ଦରକାର ପଡିବ ଅରିଜିନାଲ ସେଇଗୁଡାକ କେବଳ ଅରିଜିନାଲ ଆସୁଛି ହିୟରିଂ ବେଳେ ଆମେ ବେଳେ ବେଳେ ଲେଜିବୁଲ ହଉନି ଯୋଉଠି ଆମେ ସ୍କାନ୍ଡ କପି ଗୁଡାକ ଆମେ ମଗଉଛୁ ଅରିଜିନାଲ ଇଏଟା ପୁଣି ଦେଖିଲା ପରେ ସେଟା ଫେରି ଯାଉଛି କିନ୍ତୁ ଏଠିକି କୌଣସି ଅରିଜିନାଲ ଇଏ ରେକର୍ଡ ଅଛି କାରଣ ସବୁ ଡିଷ୍ଟ୍ରିକ୍ଟ ରେ ଏଗୁଡାକ ପ୍ରୋଭିଜନ ଆସିଗଲାଣି so you wherever you want you can go it and after few days you will not be permitted to hold this brief there will be simply a computer just think of it computer ରେ ତ pen drive ରେ ଆଣିବେ ସେଇଆକୁ ଦେଖିକି ଆର୍ଗୁମେଣ୍ଟ କରିବେ ତେଣୁ the situation is moving to that stage ହେଲା ତେଣୁ
No, LCR impact
no it's not ଏଇ ଯୋଉ ଆସୁଛି ଏଇ ଯୋଉ ଆସୁଛି ମୁଁ ଯୋଉ ଦେଖିଲି ବର୍ତ୍ତମାନ ଏଇଟା ହଉଛି ସ୍କାନ୍ଡ କପିରୁ ଗୋଟେ କପି ସେମାନେ ହାର୍ଡ କପି ବାହାର କରିକି ଆମକୁ ଦଉଛନ୍ତି ଏଇ ଯୋଉଟା ବର୍ତ୍ତମାନ ମୁଁ ଆଣି ଦେଖିଲିନି ଯୋଉଟାକୁ ଆପଣଙ୍କୁ ଇଏ କଲା ଏ କପି ଏଇଠି ହାଇକୋର୍ଟରୁ ବାହାର କରି ଦେଇଛନ୍ତି ବୁଝିଲେ ନା ତେଣୁ it's not coming here so the entire thing is that is very easy get the pen drive and ask this special right just collect it in प्रत्येक वीक रे 4टा 5टा मैटर आसुची आपनकर तेणु you will get
I will instruct the special.
that's all